5 seconds to go. Start. Not only personal liquid assets but also alternative sources of money should be considered. The eligibility of person to sue in forma pauperis has been considered in American jurisprudence as thus: the burden of establishing indigency is on the defendant claiming indigent status, who must demonstrate not that he or she is entirely destitute and without funds, but that payments for counsel would place an undue hardship on his or her ability to provide the basic necessities of life for himself or herself and his or her family. Factors particularly relevant to the determination of whether a party to a civil proceeding is indigent are the party's employment status and income, including income from government sources such as social security and unemployment benefits, the ownership of any unencumbered assets, including real or personal property and monies on deposit, and finally the party's total indebtedness and any financial assistance received from family or close friends. Where two people are living together and functioning as a single economic unit, whether married, related, or otherwise, consideration of their combined financial assets may be warranted for the purposes of determining a party's indigency status in a civil proceeding. The Code of Civil Procedure 1908 provides for mechanism by which a person who is indigent may file a suit or an appeal. Order 33 thereof pertains to filing of suits, and Order 44 deals with appeals by such persons. In the present matter, we are concerned with an appeal and we seized under Section 173 of the Motor Vehicle Act 1988. Rule 1 of Order 44 dealing with appeal filed as an indigent person reads as under: any person entitled to prefer an appeal who is unable to pay the fee required for the memorandum of appeal may present an application accompanied by a memorandum of appeal and may be allowed to appeal as an indigent person, subject in all matters including the presentation of such application to the provisions relating to suits by indigent persons insofar as those provisions are applicable. The operation of the above two provisions has been noted by this court in R.V. Dev versus Chief Secretary Government of Kerala in para 8, whereof it was observed: when an application is filed by a person said to be indigent, certain factors for considering as to whether he is so within the meaning of the said provision are required to be taken into consideration. Therefore, a person who is permitted to sue as an indigent person is liable to pay the court fees which would have been paid by him if he was not permitted to sue in that capacity if he fails in the suit at the trial or without trial. Payment of court fees, as the scheme suggests, is merely deferred. It is not altogether wiped off. In regard to the application of Order 33 of the Code, a perusal of the decision in Union Bank of India versus Khadar International Construction and others reveals the following principles. It is an enabling provision for filing of a suit by an indigent person without paying the court fee at the initial stage. If the suit is decreed for the plaintiff, the court fee would be calculated as if the plaintiff had not originally filed the suit as an indigent person. The said amount is recoverable by the state in accordance with who may ordered to pay the same in the decree. Even when a suit is dismissed, the court fee shall be recoverable by the state in the form of first charge on the subject matter of the suit. Stop.